Good evening all. We are live now and sharing the first slide. Thank you. Thank you all.
Should I start?
No, wait, madam.
Madam, with 30 seconds thamba.
Good evening, everyone.
Good evening.
Good evening. Good evening.
Good evening, all. Good evening, all.
President, sir.
Good evening. Bye. Good evening.
I will start, I think.
Yes.
Good evening, everyone. Today is 17th February, celebrated as Medico-Legal Protection Day for doctors. Learn to have legal knowledge and have safe practice to follow. On behalf of Thane Academy of Pediatrics, in association with Maha IAP and Medico-Legal chapter of IAP, I welcome you all. We are here to conduct an interactive webinar on medico-legal issues. Let me welcome our dignitaries, Dr. Sanjeev Joshi, Maha IAP President, Dr. Renu Boralkar, Maha IAP Secretary, and our guest of honor, Dr. Satish Sharma, Chairperson, Medico-Legal Chapter of IAP. Our moderators are Dr. Archana Kavalkar and Dr. Pooja Sharma. Before we begin, I would request Dr. Sanjeev Joshi to speak a few words. Over to Dr. Sanjeev.
A very good evening to all. The office bearers of the Thane Academy, Dr. Bondre ma'am, Dr. Pooja, Dr. Archana, our own EB, Dr. Gavita, Dr. Praveen Gokhale, and all the dignitaries and the luminaries from the Thane Academy. Of course, today's expert from the Medico-Legal group, respected Dr. Satish Tiwari sir, respected Hemant Gangolia sir, and my dear brother, जिनके नाम में दो युग का संगम है, राम और गोपाल, वैसे हमारे राम गोपाल, the past president of the Maharashtra IIT. I express you gratitude from the Maharashtra IIT and also welcome you on behalf of Maharashtra IIT. Friends, you know, the medico-legal knowledge is a critical bridge between your clinical excellence and legal accountability. And of course, medico-legal illiteracy was one of the prevalent situation among the practitioners, all fraternities, not only the pediatrician. But thanks to the medico-legal group for sensitizing, for teaching, for mainly the what you called the different spheres of the medical legal aspects, like the right from documentation to the prescription, uh, uh, ideal prescription writing, and everything. So I express my humble thanks to all the pioneers in this field. Like, of course, I welcome my elder brother from Haryana, Dr. Satish
Sir,
Sharma sir. Sir, welcome to
thank you,
Maharashtra
sir.
IP.
Yeah,
Welcome, sir.
thank you.
Welcome.
Good
Yes,
evening,
yes,
everyone. Good evening,
yes,
Dr.
yes.
Sanjeev.
Well,
Yes,
welcome,
Yeah,
Satish sir.
Welcome,
yeah,
sir.
and I really congratulate the Thane Academy of Pediatrics for such a wonderful activity, and I assure the medico legal chapter, Maharashtra IB would like to have you exclusively uh, on our virtual forum. We will definitely allocate 1 month to you. I think Gravita and Praveen, please take care of this. In any month, we can include medico-legal exclusive discussion on the subspecialty event. So I also welcome all the virtual attendees. Thank you for inviting me here. As you know, I have some constraint. So just signing off with a big, big thanks from the Maharashtra IP and personal regards as well. Thank you all.
Thank you for joining us,
Thank you,
sir,
sir.
even though it was for a short time. Thank you for being here.
Thank you.
Dr. Satish Sharma, I know you two are a little busy, but can you just please address the audience before you have to leave?
Good evening, everyone. At the outset, I congratulate Thane branch for organizing this celebration of prevention of violence and medical protection day for the doctors. Maharashtra IP President Dr. Sanjeev Joshi, Secretary Dr. Renu Baralkar Madam, Thane President Dr. Sudesha, Secretary Dr. Pooja Sharma, today's moderator Dr. Archana, our learned speaker and stalwart Dr. Satish Tiwari sir, Dr. Hemant Gangolia, Secretary, current Secretary of Medical Chapter, Dr. Ram Gopal Charja, Dr. Samir, Convener of Scientific Convener of Medical Chapter, all other seniors, colleagues and friends here. Why we are celebrating this Medical Protection Day? We started this in 2024. Dr. Renu was with us, because there unprecedented, unsettling rise in the medical cases against the doctors. And there are frivolous complaints, and the other on the private complaint or the police officer, they unnecessarily harass the doctor, they file the FIR. And once they file the FIR, although the cases they are frivolous, but the doctor, they are under stress, not only professionally, but their reputation is gone. So we thought of that we should aware of this civil society, the authority about the Honorable Supreme Court of India. They have addressed these issues in their judgment, and we have landmark judgment like Jacob Matthew versus Government of Punjab, Martin D'Souza versus Mohammed Asfaq. It gave judgment on 17th Feb 2005. That's why we have kept the date on 17th of February. Then Kushum Sarma versus Batra Hospital, Suresh Gupta, all these are cases. There are some, protection for the doctors. The key direction from the Supreme Court in the judgment, the private complaint may not be entertained without any prima facie or there is gross negligence on the part of the doctor. Before proceeding, the investigation officer must obtain an independent opinion from the expert witness of the same specialty, or preferably from the government hospital. And the doctor accused of such, routinely they should not be harassed, should not be arrested by the police officer, and complaint against the doctor of the hospital should be referred to a committee. Another challenges which we are facing is increasing violence against the doctors. Who is responsible for the violence? Whether the media, the public, the doctors, because there is increasing gap between doctor-patient relationship. And to protect against these violence, we have a certain law, the State Protection Act, currently which is in 26 states, including Union Territory. And this prevention of violence against medical professional and the hospital, which is a cognizable offense. So these police officers, they ignore this law, they are not aware of this law, they are ignorant about this, even we doctors are not. So that's why our aim today, under our National President Dynamic Dr. Neelam Mohan Madam and his team and Medical Chapter Office Bearer, be celebrated today at national level. The this Police Commissioner of Delhi was a chief guest, and a memorandum or a flyer was given to be sent over to the police, in which the Supreme Court judgment as well as the state what was there. So all of you should be aware of your laws, certain defense, IPC, certain defense in BNS also. If they can file FIR against us, because the punishment for medical negligence is 2 years, but assembly of doctors, assembly of miscreants, those who are doing violence, showing weapon or threat, obstructing a doctor, their punishment also 2 years. So we should also file them. So today, I think the deliberation by our three stalwarts will be a very fruitful for those who are attending, and all the IP branches, they should submit these two things, State Medical Protection Act as well as the Supreme Court judgment, so that in future our doctors, they are saved, not unnecessarily harassed. Thank you very much. Yeah.
Thank you, sir. Hello.
Thank
Yes,
you very
madam.
much, sir. Thank you
Thank
very
you, sir.
much.
Thank you, sir.
So over to Dr. Pooja. Can you
Yeah.
please start?
Yes.
I will share the presentation. Just a minute, please.
So warm welcome to all the
एक मिनट
dignitaries.
अर्चना मैडम
Yes.
before starting let us have a one or two words from our Maharashtra IP secretary and then we should start.
Okay.
Sure.
It's a protocol.
Yeah. Renu madam,
Yeah,
please
thank
say
you.
a few words before we start.
Good evening, namaskar to all. Namaskar Satish Sharma sir, our last year senior VP, and who is always a guide and mentor to all of us. And also respected Dr. Tiwari sir, Dr. Ram Gopal, my ex-president, and Gangolia sir, my president of when I was EB of MahaIP. I congratulate the team of Thane IAP for organizing this medico-legal webinar on this day of 17th Feb. And Dr. Satish Sharma sir has already told in detail, and Dr. Joshi sir has also talked about. So actually, I would like to congratulate Dr. Archana, Dr. Pooja, Dr. Sudesha ma'am, all the ladies who have come in front and now they are doing this medico-legal team. And also conducting it very dynamically and encouraging for others also to carry forward. There is no gender bias I'm talking about, but it is the unity with the Thane team. I always see and appreciate it, and all the branches should be like this, I think so. And just a few minutes back, I came to see the checklist of the medico-legal safety, and just would like to share that the 4 commandments like clear record keeping, clear communication, which is transparent, standard care, and ethical conduct, along with professional protection, was mentioned in this, and it is very, very important for us. And most important is the POXO, where we should concentrate more in further sessions. I know that medical legal chapter is very, very dynamic in our. I see because I am also a member of the medical legal group, and I always see whatever is posted in it and learn myself and relearn it, because it is very less that we understand as a general pediatrician. So congratulations to all the team for organizing this event of today's talk, and best wishes for further.
Thank you very much,
thank
madam. Thank you.
And I thank all the dignitaries for joining us today. Before we start, I would just like to introduce our experts for the evening, Dr. Hemant Gangolia, sir, who's a senior practicing pediatrician at Raigad. Sir is also the secretary for the medico-legal chapter of IAP 2026.
Pooja, may I interrupt? Can you see the presentation?
Yeah.
I'm
yes.
sharing. Can you see it?
Yes, it's visible.
It's visible?
Yes, ma'am. It is
Yes,
Visible. Yeah.
It is visible.
Okay.
So we welcome Dr. Hemant, sir. The next expert for the evening we have with us Dr. Ram Gopal Chajera, sir. Sir is the past president MahaAP 2024 and has also been the organizing chairman for a MahaPedicon and MahaNeocon and many such conferences. So thank you for joining us today, sir. And the next expert that we have with us today, Dr. Satish Tiwari, sir, who's a professor of pediatrics at Amravati and is the founder president of the Indian Medico-Legal and Ethics Association. We are honored to have all our experts with us today. So without much ado, Medico-Legal being a very vast and dynamic chapter, we'll start with our presentation immediately. I hand over to Dr. Archana Kavalkar.
Thank you, Pooja. And I welcome all the dignitaries. I will not waste any more time, and we'll straight away dive into some routine OPD case scenarios. And I would direct this question to one of the experts, but I will, invite comments from the others as well, as in where you see, appropriate. I'll direct this question first to Dr. Hemant Gangulia, sir. What are the basic resuscitation requirements that we should have in a small clinic such as ours? I am really keen to know.
Thank you very much, madam, and all respected dignitaries on this dais. Before I answer this question, just give him 1 or 2 minutes, because exactly on 17th February 2009, landmark judgment of Martin D'Souza came, and what is the crux of the judgment? Not to harass and not to arrest doctors, refer to the committee of doctors. That is the most important. Secondly, you all branches must have received the appeal and the thing from the CIP to be submitted memorandum to the police authority. Problem is with that, why the 17th February? We should make doctors, public and police aware of the facts. And therefore, some appeal has been drafted, which has been sent to CIP, also some PDF files. Though, what is the problem? That everything looks very good on the papers, but when practical implementation comes, it is a very difficult, it is different scenario. So we should establish local rapport with the local police station, having courtesy meeting at the association level. We should be united and share all the things, because I remember one of the incidents where Maharashtra Prevention of Violence and Damaged Property was not, the PI was not having, and I have to WhatsApp to him to register FIR against the miscreants under the Act. So I was involved almost 6 to 7 incidents of the violence. So this is very important. So we have to make the local awareness at the police station, because though higher official, you must have heard the national webinar at 3 o'clock. Though it is nice to hear them at the official level, but when it comes to local level, it's totally different. So we should have a rapport. We should establish a rapport and have a good meeting with them and do procedure. We should remember mishaps are the part and parcel of our practice. So we should modify our practice. So with this background, why this 17th February is celebrated, I wanted to say. So the basic resuscitation requirement in a clinic, see in a clinic in office practice also, if we give some injectables, if we give some vaccine, the mishap can occur. And when the mishap occurs, we should be able to resuscitate the child. And if we don't have any resuscitation measures, it becomes a gross negligence. And therefore, in spite of because these are known complication, mishaps can occur. But if that mishaps occur, the proper protocol, proper standard protocol, if we follow and try to do the resuscitation measures, which can be documented if something is done and the panchanama is done, so everything is there in the place, that shows you have done the resuscitation measures.
I think sir's connection is a little unstable.
Yes, you are not able to hear?
So little unstable your connection is. Yeah, intermittently it's
breaking.
Okay. If you can just repeat the last sentence, sir.
Yeah, then I will shut my video and just keep audio on. Okay.
Yeah.
So basically, if anything happens in our clinic, if while giving you some injectables or some vaccine, it can cause an adverse effect and something can occur, we should be handled with the proper resuscitation measures with the standard protocol and standard things. If we are able to manage to that, in spite of the death, there's not a gross negligence. But if we don't have these things in our clinic, then if the death occurs, we are responsible. That becomes a gross negligence. Court of law sees what you have done after the adverse event. So basic resuscitation requirement in a clinic, oxygen is a must, basic emergency medicine is a must, adrenaline is the main drug, which is to be there always, and then the ambu bag, laryngoscope, everything should be there, which can be which is helpful in the resuscitation measures.
As a follow-up to that question, sir, not many of us have small clinic spaces. So, is it necessary to make provision for an IV infusion also? Suppose you have a child who's come very dehydrated. Now, yes, we have a ambu bag. All that occupies less space, but putting in an IV and giving an infusion, etc., that too you feel is a part of the basic requirements?
So how do you define your office practice and how do you define your OPD? That depends on that. But there's an interesting case law, Permanent Katra versus Union case law, which says when any emergency brought in an office practice also, which has to be stabilized and then referred at the appropriate place in appropriate way in appropriate ambulance, in appropriate person accompanying and appropriate handling. So if that is the case, if something comes, so you should have something to be, means at least some table or some small bed or something where we can manage this thing and do the basic primary care. But the problem is that in that it is not defined what is a stabilization. We are very lucky that Clinical Establishment Act is still not implemented in Maharashtra state, whereas it is implemented in various states where it says that stabilization is mandatory and whether they are not defined stabilization. So what I feel, or otherwise what are the general consensus that whatever you can do with your limitation of the degree qualification and the OPD, you just try to establish what you can do, and best thing is if you feel, refer to the proper institution, proper place, and please accompany them in spite of having your OPD patient waiting. Best thing is always accompany and hand over at the appropriate place in an appropriate way.
Okay. Thank you very much, sir.
Dr.
I
Hemant,
think the summary
Dr.
I
is.
just
Hemant,
want to add few
Yes.
things.
Yes.
Infusion, yes, it is
Yes.
required and it is mandatory
Yes.
because suppose if you have given a vaccine and the patient goes into a vasovagal attack, the only treatment is a IV line. So you have to secure the IV line. So for infusion, has whatever small clinic, either we have to practice as per the guidelines or then don't practice. We cannot give an excuse that my clinic is small, therefore we cannot have an IV stand and I cannot have an infusion facility. Because it is the treatment. If the patient comes in a shock, your treatment is an only IV fluid.
Correct.
Now, when we say stabilize, that means you have to at least secure an IV access so that you the pulses which are feeble, you can palpate. So you have to rehydrate. So all these facilities are part of the emergency management.
Correct. Thank you, Dr. Ramgopal. So
Dr.
summarize
Hemant,
that.
Yes.
Dr. Hemant and Dr. Ramgopal, I would like to add here
Yes, sir.
that many times our colleagues have two queries in such situation.
Yes.
As Dr. Hemant and Dr. Ramgopal has already said that basic instruments and basic facilities must be there. But many of our colleagues have query that if the patient is already serious and if you try to put a IV line, try to stabilize, and then in that we take 15 to 20 minutes more and patient becomes more serious, or sometimes you give some injection as Dr. Hemant has said, we give adrenaline or suppose we give the hydrocortisone, then parents or the relatives many times have the allegation that the child has deteriorated after giving the injection.
Yes.
Yeah, that's a
Right.
valid point. What to do then?
Or we have put the IV line and that took 15 to 20 minutes. And in that 20 minutes, we have delayed the referral and our patient become more serious.
Yes.
So I think in each and every case, we cannot have a generalized statement. And we should manage each and every case on a personal experience, looking at the behavior of the parents or the relatives and whatever is the problem.
Yes,
And
sir.
sir, like you said, documentation is important, right, sir?
Yes.
Madam, I would like to add here one thing.
Yes.
What sir said, exactly this thing happens in our practical cases. I practice at the area where really peripheral and gram panchayat is there. And really the same thing happens. आपण मराठीत म्हणतो कावला बसला आणि फांदी तुटली. आपण काय करायला जायचो आणि काहीतरी गोष्टी व्हायची. That the best thing what I do in the emergency, because I now start doing intensive care because my colleague pediatrician started intensive care. What I do is that one of the sister and Maushi, both of them accompany the patient emergency immediately and go to the hospital, the nearby hospital, hand over to him. I call them, okay, I am sending this patient. If the patient is too serious, I myself accompany and go to my friend of the pediatrician who is doing the intensive care, which is just half a kilometer away. So I go, so that is a practical thing which I have to do. We don't want to waste time. Sir is absolutely right. Because ते काय म्हणतात की तुम्ही हे लावताना तुम्ही आमच्या अर्धच वेस्ट केलं, आम्ही तेवढं पोहोचलो असतो. तर we should find a practical ways depending on the case. So it is not a uniform thing, but it is a tailor-made situation.
So you have to use your
Sir.
discretion and then decide on the basis of that. I
Yes.
think
Now
we'll
Sir,
move on to the next question.
just a minute,
Ram.
sir.
Yeah.
Her question was whether you should have an eye infusion facility or not.
Yes.
So that
We will
answer
have.
is that yes,
Yes.
you
Yes,
should
yes.
have a
Dr. Ram,
infusion.
yeah, that point is taken that you should have all the basic
Yes.
resuscitation, including a facility for IV, but use the discretion where you don't have time, you shift quickly.
Yes.
Next question to Dr. Tiwari. Sir, is it advisable to keep a family waiting after vaccination for observation? Because we know that these things can happen, like a reaction can happen. What is your take on that?
Yes, as we rightly said, there are some guidelines or some regulations or some recommendations from various authorities. And as far as the vaccination is concerned, the recommendation is that after each and every vaccine, patient should be there for 20 to 25 minutes or half an hour waiting in our waiting hall, so that if any reaction has to occur, they can be managed at proper time.
Okay, sir.
So,
So, which means
as
that
per
sometimes if the
recommendation,
patient
25 minutes, yes.
Yes, but sometimes patient just walks away, sir. So is it necessary to document, like there was a thought in one of the webinars that have a blanket consent for all vaccinations, because patients who are coming with us regularly, should you have a blanket consent for vaccination and an instruction, please wait for 20 minutes after vaccination.
No, in
you get it home.
medico-legal consultation or issues, now we say there is no role of blanket consent. You should have informed consent even for vaccination. And in that consent, we can definitely, or I would say we must write that you have to wait for 25 to 30 minutes after vaccination.
Sir, do you take consent for every single vaccination that you're giving? Is it
No, personally,
viable to do that?
Personally, I'm not taking consent for every vaccination dose. What I have done, I have written at the bottom of my vaccination chart. There are 4 or 5 lines that I have been given information about the various vaccines available. I have been informed about the cost of that vaccine. I have been informed about the advantages or the use of that vaccine and the possible reactions.
Okay.
And after all this information, I am willing to take the vaccines as per my financial condition. So in
Okay.
that case, if you are not giving costly vaccines, then also you are safe. That patient was not willing, and patient also cannot have allegation that I was not informed about the costly vaccine.
Okay.
So I have these 4 or 5 lines, and I take consent once only that I have been informed this much, these many
Okay.
things.
So just caution is advisable, and
Yes.
blanket consent doesn't work. Everything has to be an informed consent.
Yes.
Next question again for you, sir. This
Yes.
digital record keeping, nowadays we have many of these fora where you can these websites where you can keep your records digitally, but not all of us are tech savvy. So
Yes.
what is your point of view on keeping digital records versus keeping a Xerox? Because the Xerox is really a big difficult task. But what is your take on digital record keeping versus record keeping overall?
No, my personal feeling is, and that is that will be accepted by the most of the courts, that records are to be maintained. So record keeping is a must, whether it is in a digital form, whether it is in the form of a hard copy or soft copy, it doesn't matter, but the record have to be there. And the another very important point which I would like to suggest here to our friends and colleagues, that please do not manipulate the record. So that is very important, whether it is digital or whether it is a hard copy, we should not try to manipulate the record.
Okay, okay, sir.
I would like to add, madam, I would like to
Any
add.
other comments? Any other comments?
Yes,
Yeah.
I would like to add, madam, digital record, whatever sir has said is okay, but still NMC is at the stay. But once NMC gets implemented, National Medical Commission gets implemented, the medical record which National Medical Commission states only for indoor record for 3 years. Point number one. Number two, once NMC gets implemented, each and every practicing medical practitioner across the country has to go digitalization within the implementation of NMC 5 years. So after 5 years, and that record will be lifelong.
No, Dr.
Sir,
Hemant,
I didn't understand. Can you please repeat this? Can you please repeat that point, sir?
National Medical Commission is still not implemented. Once implemented, all those who are doing the not digital record have to go digitalization after 5 years of the implementation of NMC.
Okay, okay.
Dr.
And you have to
Hemant,
keep.
what is Madam Archana's question is that if I am not a tech savvy, so I
Yeah.
think if we are not tech savvy, there are two options with us. As Dr. Hemant has said, once the National Commission says that our guidelines are to be followed and then everything should be digitalized. But if we are not tech savvy, then the National Medical Commission cannot say that you have to maintain digital record only, because the hard copies are more safe, hard copies are more easy to reproduce, hard copies there are less chances to be manipulated. So all these things are there. Hard copy, no court will reject that why you do not have digital record. So hard copies will be equally important in the court of law, in the National Medical Commission. And of course, as you said, if I am not tech savvy, then if you have the sufficient funds, you can definitely keep a computer person on your roll.
Okay, so maybe you can take a
In
photograph
short,
and save as a PDF.
madam,
Maybe that is an easy thing also.
in short, you have to keep the record, whether you want to keep
Yes.
it in as a
Yes.
physical or digital, at your convenient form, you
Yes.
decide. But you
Yes.
have to keep the record. That's all.
Yes.
Yeah, yeah. And indoor records for 3 years and OPD records for
No,
5 years,
no.
right?
No.
Only indoor records for 3 years.
At
Only.
present, recommendation is only for indoor records by the National Medical Commission for 3 years, as Dr. Ram Gopal has said. But we as a medico-legal consultant say that even if you have a OPD record, it will be better for us to defend the case.
So before I proceed with the next question for Dr. Ram, I want you to close this technical thing by saying that by giving your views on having CCTV camera, and is it necessary, and what should be the location for the camera?
It is better to have a CCTV camera. There is no clear-cut rules that you must have. But in today's world, it is always better. That is for the your safety. So that because the recordings can be used. Yes. Now, first thing, it should not be in the examination area. The examination part is always a personal thing. So that is more important. Secondly, it must have a notice that you are under CCTV surveillance. Third thing, so many cameras comes without voice. It is better to have a camera with voice, because when you are counseling the patient, nowadays what happened, the communication is the most important. Once you, so many things, you cannot write everything, which is practically not possible. So when you counsel the patient regarding the treatment, whatever charges, we say so many things. If it is under the camera which has got a voice recording also, your conversation is recorded. So if the patient refuses that we have not said certain things, you can always produce that recording to the court and you can save yourself.
No, but examination area, you said there should be no camera, right? But because most of us have the same examination area.
So you have to have a curtain, na? Now, if a elder female is there, you are examining the patient. Sometime it requires the removal of the clothes also. You cannot record that. It is a privacy.
I obviously understand, but then keeping a camera in the counseling area is important, you're saying?
Yes, it is very important in the counseling area, but because ultimately you are saving yourself. It is not for the patient, it is for yourself. That yes, you have counseled.
Okay.
Nowadays, in fact, bigger hospitals, they have started a counseling room where there is a CCTV. So they always do the counseling in that counseling room.
Yes. Madam, I can say one thing.
Yes.
Your point is very well taken because we do have examination and consulting in a one room only.
Yes,
So
yes, that's
we should always think of way outs. The way out is putting the curtain across the camera and this examination. So when you
correct.
are doing examination, put the curtain sufficiently that it get hidden by the camera, and then you
Yeah,
can do
because the
it.
patient should not be
Yes.
uncomfortable. They don't
But
know the
yeah.
location of the camera.
But at the same time, if and Dr. Ram Gopal has said exactly the proper thing that it should be audio as well as video. And so when you do this break, put the curtain, you should always say to the patient, see, though this is having camera, I am putting the curtain, I am examining you. Just to document the communication form. That's all. Bas.
Okay, sir.
Dr.
Next question
Gauri has
again.
raised, Madam, Dr. Gauri has raised the hand. Let
Yes.
us what
Uh,
she wants
uh,
to
uh,
say.
Pooja,
And
can you
then I
just see
will add
Gauri's
to
question?
what Dr. Ram Gopal and Dr. Hemant has said.
Has not put any question in the chat box.
Okay. I think what we are doing is we're going to read questions from the chat box. Unfortunately, we don't have time to let people speak. So Dr. Pooja will please see the question and yeah, keep it aside.
Okay, okay. So let
Next
me
question.
add, Archana Madam, let me add what Dr. Ram Gopal and Dr. Hemant has said.
Yes, sir. Yes, sir. Please,
That
please.
CCTV is a must. The audio video recording is a must.
Yes.
There is no doubt. Because many times the allegation that we came at 10 o'clock and we were allowed to wait in the uh, waiting hall for 2 hours. The doctor came at 12 hours, at 12 p.m. And then my child became serious. So all this can be taken care only by when the patient come if you have recording and everything.
Okay.
As far
Thank
as
you.
Dr. Ram Gopal has said, communication is always to be recorded because patient subsequently cannot say that we were not informed about this and all this. So that will have a better communication recording. And the last point about the examination, I think even if you are recording the examination of the some parts which should not be recorded, I think if we are
Yes.
recording that also, there is no harm because many times there can be allegation of molestation, especially when we are doing the SMR rating. So if we are recording, that can show what we have examined and how we have examined. But the main important point is if we have recorded the examination of the sexual part or the private body parts, then the identity should not be disclosed. So we have to maintain the confidentiality, and that examination part which we has been recorded should not be misused as a pornographic film or as a some recording which goes viral on the media. So I think if we take that care, we can even record the examination part. There is no harm. Rather, it will be protect us in case of there is allegation of molestation or something like that.
Actually, this is really news to me, sir. For the first time, I heard something like this because don't you have to take consent if you're recording, especially an examination?
Yes, you have to take the consent. If you are recording, you have to take the consent, as Dr. Ram Gopal Chejara has said, that you have to put a notice in the waiting hall or in the room that you are under CCTV coverage. Only precaution what I feel as a medical legal consultant, that even if you are recording the examination of the sex maturity rating, we should maintain the confidentiality, and that part of the recording should not be misused because
Sir, there
this
is a risk in that
yeah, I
because the
know.
recordings are always handled by the paramedical staff.
that
As a
that is
doctor, we don't have an secrecy of maintaining the recording. So that
Can
always
be
has a high
misused.
chance. So better to have a curtain and avoid such incidences.
Dr.
Second
Ram
thing,
Gopal, that is what I am saying, that if we are recording it, it should not be misused. So we will have to keep supervision or we have to keep
so
control over
I
the
would advise
paramedical.
only record where it is the necessary. Sometime, yes, definitely some POXO child is coming or something which has got okay that can be used, but not for all cases. So better to have a curtain and avoid such incidences.
No,
Yeah.
all cases means what? If you are doing the examination recording of a 5-year-old child who does not have the breast development, even if you are
Sir,
recording
tomorrow the
breast
parents will
examination,
go
what
and
is the point?
accuse that the doctor has touched the private part. He has recorded
That
my
that
child,
is what we are
and they
saying. If
might
you
bring
are,
some Manse leader and create a havoc in the clinic. So why to
that,
Yeah, I
why?
think, sir, I
that is
think
what
here
I
we
am
will
saying.
agree to
If you
disagree
take
a
the
little.
consent and keep the record, so that
Yeah.
tomorrow they do not have allegation that molestation was done.
Okay. So here
Most important
we will
thing,
wait for some, we will probably get some clarity after more discussion.
and
So we'll move on to the next question. Yeah.
one
Uh,
important thing is ki even if you put the camera in the waiting area is also must, because recently 1.5 months back there was a case where the patient has said that he was attended after 2 years, whereas the CCTV recording showed that he was attended within 15 minutes.
Yeah, that is what I am saying, that timing is very important. That
Hmm.
Yeah.
allegation that we were waiting for 2 hours and by that time my child becomes serious cannot be, an allegation cannot be there if you have a recording.
Okay. Next question to again to Dr. Ram Gopal. Now, if I have advised urgent admission to a child with, let's say, acute severe asthma, there is the saturations are 89, 90, and the patient insists that you give me medication. What is advisable in this case?
See, whenever you feel there is an admission is required, you have to document and write on paper that yes, admission is required. If they refuse, so you have to again take an informed consent that yes, you have advised the admission because you feel the child is serious, but the relatives are not willing for the admission, and keep at least one don't hand over that OPD paper to him because you have taken a signature on the OPD paper. So keep the copy of it that yes, you had advised the admission and there is an informed consent that admission was advised. Again, the consent has to be the language which the ideally it should be handwritten by the parents. That is the most thing. If they cannot write, then at least write in the language which they understand. Don't write, take a blanket
English.
English consent. That is most important thing.
Okay. Okay. Thank you very much.
Dr.
Next question
Hemant,
to
you
Dr.
want to add
Hemant.
something?
Yes, yes, sir. Yes,
Dr.
sir.
Hemant, you want to add something on this?
Okay. Now the question was, are we vicariously responsible if wrong drug is dispensed by the pharmacy?
No, no, no. He was asking, sir, if you want
For
to
the
add
first
something about
question,
the
first
first
No,
question.
no.
question.
Yes.
No, my suggestion here will be that if the patients are not willing for admission, then please do not prescribe medication. You can tell them that this patient is serious. He
Yes.
cannot be managed on OPD basis. So if you are not willing for admission, you please go to some other hospital, but I will not prescribe medicine
That is an
because
important point, sir.
uh,
Very
this,
important point, sir.
this child cannot be managed on OPD basis.
Okay.
Yes.
So you may
Next,
lose 1 or 2 patients, but you will be safe in your practice.
very true, sir. Very true, sir.
Okay.
The next question to Dr. Hemant. Sir, are we vicariously responsible if the pharmacy prescribes the wrong drug? You may write it in capital letters, but they prescribe the wrong drug and patient starts taking it. Are we vicariously responsible?
So there is one of the interesting case law where the medicine was prescribed and instead of the this one of the medicine, the diabetic medicines were given, and then but that was a case of illegible handwriting. So what you say here is that you have written the medicines properly in a capital letter. So I presume that is a readable. When it
That's
is
what I'm
readable,
saying.
that is the responsibility of the pharmacy to give proper drugs. If it doesn't give proper drug, and so way out, always I think say always I say way out. Way out is always I at least I insist on every patient to show the medicines to our staff or myself and check the drugs and then dispense. But somehow some of the patient they do not listen in spite of this and they go away. And then it is their job. So if it is really written properly, then it is not. It is a court of law will judge and will decide, and probably in that case we will not be held in liable, but it will be totally pharmacy. But our handwriting is not readable and is not readable and it is a query, then probably we will also, the vicar will be responsible and compensation has to be given by us also.
Okay. Next question again to you only, sir. What care should we take when issuing medical certificate after illness? Patient has taken treatment for us, but still, because they will add few days, etc. After this illness, I went for this one's wedding and all that. So these things happen. Practical problems, sir. What
So,
care?
so medical certificate and its issues itself is a big topic. And I am very glad to see that Dr. Samir Sadawarti, who always speak on these certificates. So he's there. He may correct me, but I will say the basic things. Any medical certificate, whatever he one issues, please see that he was under a treatment. Most of the time they take the treatment on, suppose today is the 17th and they are ill from 14th. They will ask us to write 14 date. We should never. Whatever the day we have examined, we have to write from that day. And for how many days you want to give advice rest, that depends on the situation, the condition. But you should examine the child and you should give the certificate accordingly. And then while giving certificate, we should not write to whomsoever it may concern. It should be always addressed to the people where you want to give the certificate. And of course, 15 days is the period where you can, when you have examined the patient, you can give the certificate. But the bottom line, again, I will say the bottom line while issuing in any type of certificate in medical legal case or in our practice is that if one gives any certificate, whatever you write on the certificate, and if you are presuming that if something happens and the court of law summon to us, and if you are able to justify your certificate, your document, then only issue. Otherwise, never issue such certificates. And therefore, and also whenever mostly say they want to leave for the government hospital and the government job, there we give this certificate, we should not give.
Okay.
And
Dr.
then one more latest. I think so. When we will get time in discussion, Samir Sadawate may add to this. These days now, school admissions, they ask the fitness certificate for the
That
children.
was the next question, sir.
Okay, that is
Please
okay.
take
Okay.
that. Please take that.
Yes,
Please take
yes,
that.
yes, yes.
Dr. Sameer, you want to comment on the fitness certificate for any walk-in patient? You just happen to
Yes.
be there. Welcome. And please just give a quick comment on this, please. Tana, unmute karta ka, madam? Sameer Sarana?
I think Samir has left.
Okay, okay. So fitness certificate ka aap baat
Can I
Yeah,
add
Ram,
in the
Dr.
previous
Ram.
certificate one point?
Yes.
Don't issue a prolonged certificate at
Yes.
any given time. It should not be more than 14 days.
Okay. Dr.
If
Ram, then
the-
you take the fitness certificate question also. Many times these walk-in
I'll
patients
just
come.
add first in that. If the patient is like tuberculosis also or anything, where you give another certificate after 14 days, but don't issue one certificate for 30 days, 45 days.
Yes.
Okay, like sometimes we see an infective hepatitis also. So just give it for 14 days, reassess, and then give a new certificate.
Okay.
Now, this fitness certificate, see, it is the most commonly the patient comes for the fitness. Most of us have a habit, yes, they will just check the patient and issue the certificate. No. We don't know what the patient is. Sometimes it involves the severe exertions also. You cannot find everything, but basic investigations and basic examinations are must. So many times the patient just relatives come, we want certificate because the child has to go for a swimming or something. So unless until you examine the child properly, see for the build, height, take a proper weight, and then at least basic investigations, CBC, the child is not anemic, there is no infection, and urine routine, and a chest x-ray, at least the sometime nowadays, if possible, ECG, yes, it is not mandatory, but if on a safer side, if you take it, always better. If any symptoms or any history which point out that there could be some cardiac involvement, so preferably 2D echo, but not mandatory. At least this basic investigation, if you do, you are safe on paper and write on paper. These are the investigations done within the normal limit, and then issue a certificate. And Gangulia sir might add to it.
Yeah. Actually, we are already only on OPD cases. We have many things to do.
One or two lines. This is practical thing which I face. I practice at periphery, and the patient is getting operated at Thane or Kalyan, and he comes for fitness certificate from my side. I always say, because you are getting to operate at Kalyan or Thane, mostly the ophthalmic cases or the pediatric surgeon cases, you should take the fitness certificate from the same area which is pediatrician attached to that surgical branch. It is always better. So never issue fitness certificate in such cases when you are located other place where the surgery is going to take other places. That is one thing. And secondly, many times for ECG, they asked us to prescribe that dose of the triclophos right from the pediatrician give to us. So that we can give, that you can write properly dose as per the weight and then just prescribe that. But write on the paper as take my advice or as asked by this person for ECG, I am prescribed this medicine and this is the dose for that child. And
Okay.
with proper
Very
instruction when
important,
it
I
is
think.
given.
Because very often our colleagues just ask us write the sedation dose and we just write
Yes,
it, but we should write for this particular time or
yes,
for this particular procedure, and this is for a single time. That is a
yes.
very important point, sir. Thank you very much. Sir Tiwari, sir, the next question, actually both the questions you take one by one, please, because we are running short of time. We've not gone to the next section. What you just mentioned, precautions to be taken by male pediatrician while examining a teenage girl. You just brought up that point, so I think we won't discuss that. The next question is for you, sir. What do I do if a patient is brought dead to my OPD? This is for Tiwari, sir.
Okay, I think again here there are two or three situations. What if the patient is brought dead in the OPD? If he's our known patient, he is coming to us for last 6 months or 1 year, or is a regular patient. We know what the disease is suffering from. Like we said, there may be some congenital cardiac problem which can have sudden death, or there can be some renal problem, chronic renal failure where death can occur. So if you know the cause of the death, then there is no problem. We can issue the death certificate. Of course, if the cause of death is not known and we feel that the patient is already dead, then we have to refer the patient to the police for suggested postmortem examination. That is another thing which we have to keep in mind. And in unknown cases, please do not get carried away that you are a good doctor and you always help us. So give certificate in this case also. Please do not do that. Do not give false certificate. And of course, if the patient is really dead, then there is no need to refer him to another hospital. But whether to make, we do not know how much time earlier he has died, whether it is 5 minutes or 10 minutes or 15 minutes. So whether to do the resuscitative measures or not, that again, as we discussed for the emergency patient, here will have to decide on individual case to case based scenario. What are the types of relatives? How many relatives are there? How many, whether we feel they can create nuisance. So depending upon this, we can decide the future action.
Is it necessary to do an ECG, sir? Just to be safe.
Yeah, if there are no clear-cut signs, as we said, of death about 2 or 3 hours back, like postmortem lividity or the other problems which we can diagnose that the death is almost 2 or 3 hours back, then the ECG should be done to confirm the death.
Okay.
Or before starting the resuscitation measure. Because as we discussed, if you give anything, if you give injection, even adrenaline, that the heart might have stopped just 2 or 3 minutes back, and then you say after giving that injection that this child is dead now, then the parents may again have the allegation that the child died because of your injection. And when we brought him, he was alive, and because of your treatment or delay in the treatment, the child died in your hospital. So we have to confirm it. We may not admit him, but we make a OPD paper on write on that the child was brought dead, and we tried to resuscitate the child, and the child could not be revived. Now this, as we said, may not be helpful at immediately, but in court of law, this point will stand that we have tried to give the emergency care.
Okay. Thank you, sir. Dr. Ramgopal, the next two questions are for you.
I'll just add one or two lines in, sirs. Once the patient comes, you said about the ECG. ECG is not mandatory, but it should be done wherever the facility is available. just to save yourself. One thing.
Yourself, yeah.
Yeah. Second thing, once the patient is brought dead, you examine, you declare that what I feel, the child is already dead, but I am going to try the resuscitation measure. So you have informed, but you should try. Sometime, I think in rare cases, we have seen the coming heart rate coming up after some time, even for some time. May not be, the child may not be alive. So then they'd be, so once if you do the baseline ECG, that means there is no cardiac activity. You had proven that, you have informed them, tried resuscitation. Third thing, don't issue a certificate. The most common scenario, the relative says, हम अपने GP से certificate ले लेंगे, हमको जाना है. When unknown patient comes, don't allow that. You have to inform the police that such and such the patient was brought dead, and whatever, don't, if you know the cause, if you have seen in last 14 days it's a chronic disease, as sir already said, that you can issue a certificate, but wherever the cause is not known, the patient is unknown, don't issue. But at the same time, if they want to take the child to take a certificate from GP, okay, you don't give, we'll go to the GP and take the certificate. Don't permit that. Inform the police. That's all.
Yeah. Okay. Inform the police, but they will go anyways, I guess.
Madam, one line to add what Dr. Ram Gopal said. In such panic situation, when we declare dead, they just take the child and run away. So
Absolutely. That's what I said. They will go ahead.
First thing before examining, we should know who's the patient and who's from where, the at least name and address. So if the patient runs away, it's okay. But inform the police such a patient was brought at this time and he ran away from. That is important.
Okay, sir. Dr. Ram, next two questions for you. Can I do small procedures in my clinic, like minor burns, dressing, abscess, drainage, if I have, some basic resus facilities, and if I take consent for the same, how long do I have to preserve that? Both these questions, one by one.
Any procedure, small procedure, which are OPD procedure, you can do all OPD procedure in your OPD. Like suturing, abscess, whatever. Any procedure where there is an intervention, always you should take the consent.
Okay.
That consent has to be preserved at least, if we go by the procedure rule, 3 years, but not 3 years like, okay, आपने abscess दिया, healing हो गया, उसके थोड़े दिन बाद तक, that is an individual decision कि whether हाँ, अगर कुछ medico-legal है, if somebody has hit a road accident, like there is the tomorrow that might go to the court of law, there is a CLW, you sutured it, but that consent you preserved. But later on, if there is no inquiry or anything, you can dispose it off. But there is no definite time frame. I think there is no clear-cut guidelines for that, like an indoor case paper, 3 years, OPD, you need not require. Or yes, Gangulia, sir.
If the patient falls in your clinic itself and gets a CLW, I mean, what are we supposed to do? Can it come back to us, like come back and hit us, like, Many times the kids are playing and he gets a CLW. So
any procedure you need to take a consent. Even if it happened in front of you, you need to take a consent, because ultimately you are doing a procedure, you are using a local anesthesia which can cause any anaphylactic reaction. So you need to take a consent.
Maybe do it free of charge because it fell in your child.
See, charging or not charging is your individual decision. It has no rule.
Okay.
And ultimately, the decision depends on the judge कि वो कैसे देखता है. Same thing, he can clear out in one decision, and second judge might say कि no, you are guilty of it. So that is the judiciary.
Yeah. Okay. Now, one last question for Dr. Tiwari before we move to the next segment.
Okay, yeah.
Sir, this is the last question for you. Sorry, sir. Please repeat, sir.
Go to the next question, then I will add what Dr. Ram Gopal has said.
Okay, sir. Okay,
abscess, drainage, and burn dressing.
Single question, sir. Do you display your consultation fees in the reception area? Should you display consultation fees in reception area? This is for Dr. Tiwari, if you can please.
Now, before I answer to that, what I would like to say about the abscess, drainage, and minor burn dressing. I think as per the medical knowledge is concerned, we have done all this during our post-graduation. So as far as the medical knowledge is concerned and as far as law is concerned, there is no restriction on doing the small abscess drainage, especially at the site of which is not a very important site, like somewhere in the
Thigh or the
near the brain or near the heart or the chest. There
Mhm.
is no harm. Minor burn dressing also. Many times the dressing is not required also burn. Now we say the open treatment exposure to the environment. But at the same time, I would like to inform our colleagues that we are in an era where the medico-legal cases are increasing. So we should be aware that every patient is a future litigant. They can go to the court on simple ground that you are not surgeon, why you are drained the abscess.
Mhm.
So if you are not worried, Dr. Ram Gopal said that there is no question of money. So I would say that if you are not interested in earning the money by doing the small abscess drainage or minor burn dressing, please refer him to surgeon at least once. Take the opinion of the surgeon, and then you can subsequently do the burn dressing. So that is what is
First
my
question.
suggestion. Okay. Is it necessary to display consultation fee as you said? I was also thinking that it is not because it is written on our card or on our file also. So it is not mandatory to display in the reception area. But at the same time, as per the what Dr. Hemant Gangulia sir was saying, that as per the Clinical Establishment Act, which is not in at present in Maharashtra, but I have come to know through the collector's office or through the commissioner office that there are some letters from the collectors or the commissioner that the whatever charges you are taking, not only consultation fee, but also the injection charges, the vaccine charges, small procedure, as you said, that if you are doing the dressing charges, then that has to be displayed in the hospital. So somewhere it has to be displayed, whether it is in the reception area or whether it is in your file or somewhere else. The only difference is that if you are writing only on the file or the card, patient may say we have not seen it earlier. And if you keep it in the reception area, it's obvious to everyone, and then later on they cannot say that we are not knowing that your fees is so much or you charge so much for the vaccination. So
Okay.
that's why it should be there in the reception area.
Sure, sir. Thank you, sir. I
Madam,
think,
one line,
yeah,
madam,
yes, sir.
one line to add. What Dr. Tiwari sir said in our Raigad district and probably in Thane also. Civil surgeon has started inspecting the nursing homes and the clinics, and they have asked to write the rates to be displayed, services offered, as well as the rights and duties of the patient, as well as the right and duties of the doctors. That has to be displayed, and they have come with a checklist and they were marking tick tick. They have come to my nursing home also. So they are making all everything digitalized. This was of Raigad. I don't know about Thane what is happening. And of course, when Clinical Establishment Act will come, it will be mandatory. At present, depends on the Raigad district officials, civil surgeons, and the DHO.
I think in big hospitals, they have to display what services are being offered, sir. But in
So
small
what they do
clinics,
in big hospitals, they every patients they give an individualized budget, and then they take out the print and they take the signature of the relative that they have been given the budget or the charges.
okay. We'll
This is
move
how
on to
they
the next
display
section.
it.
Actually, sir, till 10, we are just discussing OPD cases. We'll quickly move on to casualty section. I'll hand over to Dr. Pooja. Dr. Pooja, please take over.
Yeah, so
No, the
moving on from
Archana madam carry home message from this your comment is that for medical legal webinar 1 hour is not sufficient.
I know, sir, it's too much. Having
We
so many
have
things
taken
here.
every topic for 1 hour. Ganguly sir must be knowing in that 1 year, a consent for 1 hour, 1 hour, it used to take 2 hours.
I know,
Yes.
sir. So we have so many sections now. Let's move on to the PICU section. Dr. Pooja,
Hopefully,
please.
we can move a little faster with our
Faster.
ICU section now. So, first case, I would like Dr. Ram Gopal to comment. 5-year-old child brought to casualty in shock, and patient is not registered, and there is no official admission as yet. So, what is the utmost priority? Do we first resuscitate the patient, or do we first ask them to register and get the
See,
admission?
you have to start the treatment as early as possible. Even
Right.
the government says that you have to first stabilize the people. Nowadays, that previous fear of involving police or the paperwork has gone. Now, in emergency situation, it is clear cut that you have to intervene first and then do the other things later on.
Right. So, but then, sir, at times we have to do certain interventions like intubation or maybe securing a central line. So, can we go ahead with that immediately without
See,
getting a
any
written consent from the
intervention
parents?
which is life saving doesn't require the consent. You can go even without, where it is life saving.
Right.
Otherwise, all the procedures you require say consent. But in
Okay.
certain situation where it is life saving, you don't need to go and take a separate consent for intubation, because that intubation is life saving for that patient.
Even for that matter, if you have to secure a central line, we can go ahead
Yes,
without
yes.
getting a consent.
In any situation where it is life saving,
Right.
you need not take a consent, but always we advise that one person, your assistant, goes and explain, always better. I think
Right.
Gangulia sir wants to add.
So, Section 30 of BNA states, act done in good faith for benefit of a person without consent in emergency can be done. But
Okay.
at the same time, that emergency should be documented. Really,
Hmm.
it was an emergency or not. And
Right.
once you finish all this tabulation, you can write the notes afterwards and you can take the consent afterwards. There's no problem in that. So, in emergency, you have to proceed without thinking over it and make the, but chronology of the sequence of the events should be done properly documented. That is the most important.
Right. So, for
And
this patient,
Dr. Pooja, one thing I would like to add, if
yes,
we
sir.
are giving emergency treatment and after that stabilizing, if the patient you are referring or patient is going to some other hospital,
Hmm.
and if he does not pay the bill, then you cannot ask that I have saved
Yes.
the life of your patient. So
Hmm.
you have to pay at least whatever I am asking, that much. So
Right.
we have to forget money part even if you have given emergency treatment.
I know.
Absolutely.
But
Hemant
but
sir.
at the same time, make the proper bill and let them what they pay and just
Yes.
Yeah.
but preparation of the receipt is must. If you don't prepare the bill, that means that you have some guilty mind. Always
Correct.
prepare the bill, let them pay or don't pay. That is their part.
True, because in nowadays I think there's no value for free service also. So we make
Yes.
a proper bill and we can ask them to pay whatever they are
Whatever.
comfortable with
Yes.
before referring the patient. So in this case, the patient was given the immediate attention and then was shifted to the PICU and started on treatment like ventilation, fluids, and inotropic support. Ma'am, you'll have to move. Yeah. You counsel the parents about the grave prognosis, but after some time, the child shows some improvement, but later on, unfortunately, has a massive GI bleed, after which again the child deteriorates and expires. Now, upon hearing this news, the relatives get really aggressive and they start blaming you and they get violent also. So, how do we deal with such a situation? Wherein you had counseled them that the child is sick, but in between, since the child showed some improvement, there was some hope, but unfortunately then the child expires, and which causes this violent nature. So how do we proceed with this, Dr. Satish?
Yeah, I think the answer is simple, that you don't give the patient is good so early, that if the patient has come, he is serious, after 15 minutes or 1 hour of resuscitating that patient or giving the emergency care and stabilizing. Don't say that I am the best pediatrician and you came on time and everything is all right now. It's
Right.
because of my treatment your child has become normal. We should always give guarded prognosis that your child was serious.
Yeah.
I have tried to give the emergency care, but what will happen to the child? I cannot say it at present immediately. We will have to observe this child for 48 to 72 hours.
Fair enough. So
And
we,
whatever is the outcome. So we should always give guarded prognosis,
right.
guarantee for the care and not for the cure, that you have come to the best hospital and everything will become all right.
Right. Agreed. Hemant sir wants to add something to this.
The interesting word I want to add, guarded counseling, guarded communication.
Right. Yeah. So
The
we have
most important
very
again
guarded.
is that documentation and communication.
Yes.
Yes.
Patient at any stage should feel that you are worried about the child.
Correct.
Unless until they feel that you are only a businessman, then the problem occurs. But if you counsel them properly, explain them, I think 90% of the things can be solved only on communication.
Yeah. So I think care, all of us would be doing more or less the same thing, but counseling plays a major role here when we are handling critical cases like these.
Well,
Yes,
Yes,
Hemant sir.
counseling and most
Yes.
important
And
is
one more
guarded
thing important I
prognosis.
will add, in any situation where you feel there can be some problem, always inform police in advance so that the damage to the property and other physical problem can be avoided. So you
Yeah,
have to be little bit vigilant about it.
Yes,
absolutely agree.
one point I too want to make. The
Yes, sir.
point here is missing is whether when the patient got better, whether that setup was fully equipped. Some infrastructure, if it is missing and so deterioration is there, and
Yeah.
more the facilities are required, so we should be able to justify that also. If we
Correct.
feel in keeping this patient, he will need more infrastructure, more
Yeah.
facilities,
Once we
we have to
stabilize, we can think of shifting the patient to a
shifting, or we have to
better.
inform the patient. Patient has to take the decision. So that
Right.
has to come in the counseling, in the documentation.
Correct. Correct. So, in case of a death, if this case goes to the court, then how is the medical legal culpability apportioned to the referring pediatrician, intensivist, and all the other team involved? Hemant sir?
So whenever any medical legal case goes to the litigation, the inquiry goes. Now, in such cases, the two or three things can happen. If they can do FIR, or
Yeah.
they can do go to consumer, or go to the criminal court private complaint. But don't worry about the criminal court and the this consumer forum. You have sufficient time to get the notice and respond. But the issue is with a certain FIR if they do, and the police comes and intervenes, then there is a problem. But still, whenever there is an inquiry, the inquiry proceeds from the patient where he started the journey of the treatment. And
Right.
all the sequences have been documented, all the statements are taken, all the evidence has been collected, and they make a report. And that report has been to submit to the committee of doctors. And then if they feel that it is a prima facie of negligence, at what part they proceed with that. And then probably all these three parties or four parties, wherever the patient has come from the general practitioner consultant, then primary hospital, maybe tertiary hospital, all that will be investigated. And at some point of time, if they feel, then somebody will be acquitted, and accordingly it will be proportionate according to the prima facie of the negligence at each point of time.
Right. Got it.
Dr.
Case cannot be registered unless until the board of medical board gives yes, there is a negligence which has occurred or not. Unless until the report comes, ideally the doctor cannot be arrested.
Yes.
Okay.
No, one more point. When many of our doctors feel that FIR cannot be done, FIR can be done.
FIR can be, but
Citizen
cannot
of
be
India,
arrested. I said the word arrested.
every citizen of India across the country can do FIR. So against the FIR, but they cannot arrest. And that is the theme of our 17th February, that not to arrest doctors unless refer to the committee of doctors. If prima facie of negligence, then in district president it goes to the civil surgeons. In the metropolitan cities it goes to the medical college. As in Mumbai it is a JJ, whereas in Raigad it is a civil surgeon. Thane it will be a civil surgeon office.
Civil surgeon.
And when they found the report and they submit, then the police film. And once the prima facie of negligence is not written in by the committee doctors, case gets closed there itself. But
Okay.
still, the patient has the right. He may write to the health minister. I have seen many cases where the case was closed at the police station, but then this complaint goes to the health minister, and they file open, but nothing will happen. 100%.
Okay. Point taken, sir. Now, during the treatment course, we secured an arterial line, but unfortunately, it leads to a gangrene. So, what are the medico-legal implications in such a case? Many a times it causes a gangrene. Many a times the arterial, while removing the line just slips and
Yes.
moves to some other part of the body. So, then what are the medico-legal implications on us? Dr. Satish, if you could take this question,
Yes.
please.
Now, any complication, forget about the arterial line and gangrene, any complication which are known complication, if they are occurring, The basic legal concept is that you have to diagnose it as early as possible, and not only diagnose, you have to treat it as early as possible. So even if it is leading to gangrene, whether you have diagnosed it at the early stage or not, even if you have diagnosed, whether you have given the proper treatment or not, whether you have taken the opinion of the surgeon and the opinion of the vascular surgeon, and after that, if the gangrene occurs, I think it will not be a culpable
So if
negligence.
it requires any intervention, sir, like if you have to remove the line, which adds
Yeah.
on to the bill and the charges of the patient. So
Yes.
of course they'll question you that, it's because of your mishandling of the case that, another specialty was involved and hence the charges have increased. So what do we do in that case? Do we waive off those charges or how do we go about it?
No, that two or three things should be clear in the mind of each and everyone who is attending today's webinar, that you cannot do anything for the money.
Yeah.
Whatever you have to do, you have to justify why you have done this. If the patient is not doing, then you have to ask the patient that you are not doing this. So you can go to some other hospital or some other doctor. Because if you are feeling that I am charging more and you don't want to do that, so you are free to go to other hospitals. So we should not worry that we will lose one or two
No,
patients.
sir, they might question us that, it was because of
Yeah,
your
that is what
mishandling.
I am saying, madam. Patient, as Dr. Hemant has said, we are living in a democratic country. It is the right of each and every individual to have any allegation against anybody. So you can have allegation against the chief minister, you can have allegations against the prime minister or the president of India. And whether those allegations are proper or not, that has to be proved or defended in the court of law if the case goes. And if the allegations are wrong, you have also the option to go for the defamation suit. So every option is available. So you cannot restrict anybody from making any allegation.
You have to do the right thing at right time.
Yes.
That is the main crux, that you do the right thing at right time. Rest is all secondary.
Yes.
Whether you charge, how much you charge, वो होता रहेगा. But you have to do the right thing at right time.
Yeah.
So,
So
madam,
Hemant sir wants to, yeah.
I will just add one line. Prompt recognition, prompt treatment, appropriate method to be adopted. That is the answer. Take home message for that. The question what you wanted actually know that the charges increase. Yes, we should explain to the patient. Yes, this happened because of this. We should admit no problem in that. But these are the charges. But then you can document the charges, but need not take. You can decide. But most of the patients, what they do, they say, नहीं, कॉम्बिनेशन आप मत करो, हमको दूसरे हॉस्पिटल जाना है, हम दूसरी जगह जाएंगे. Let them go, and then they send the notice that we went to that hospital, Ram Gopal's hospital, and he charged me 1 lakh, 2 lakh, and then you have to pay. That is the other part of the
It's
question.
very simple. Even in the medical illness, sometimes you give a right treatment, but still the complications occurs and the stay increases. So what you do? You have to charge for that extra stay.
Yes.
Agreed. Agreed. Yeah. So moving on to our next case. So this was a case wherein the PICU admission was for 20 days, and then the patient was brain dead. But the parents refused to sign a DNR. So what do we do next, Dr. Ramgopal?
See, unless until even you cannot stop resuscitation.
Yeah.
If the patient is not willing, he is willing to spend, why to take a DNR? We have to give the treatment.
Okay. Okay. But after a few days, they didn't sign the DNR, but after a few days, now they insist that since the patient is not showing any response to the treatment, they insist on withdrawing the support. So then how do we go about it?
See, it's a very clear cut. Now the ICMR has given few guidelines. According to that, yes, nowadays in India also they can sign the DNR, but when the patient is branded, you know that stopping will not cause any harm. But in certain situation where stopping can cause more harm, you cannot. But when there is a branded, you can always take the signature and you can stop the treatment.
Okay.
But Dr. Ram, may I ask a question? In our country, is brain death considered to be death? Because it's cardiac.
See, initially there was some issues, but nowadays ICMR has given few clear-cut guidelines if you follow that guidelines, there is no issue. Yes, sir, Gangulia, sir.
So what Dr. Ram Gopal said is exactly. But if patient science, everything is okay. But there are definitely guidelines are there, and different guideline probably. I may not take the name of the hospital, but it is in Thane also that there's a complete procedure to be adopted while withdrawing the support. We have to
Yes.
follow that and then just decide that. Just giving their consent, taking signature does not allow us.
That is what I said, sir. ICMR
Yes.
has given the
Yes.
clear-cut guidelines. These are a few
So
pages of guidelines how to go about it. You cannot
so,
say in one line.
so in case of brain dead, and you can take the help of, I will name the hospital. Jupiter Hospital has this total protocol for that. And because I know them very well, so you can just ask about this and how to, because you are the people who are practicing Thane city area where such cases often occur. So you just make a protocol at the association level. What one should do when this thing arises, make a protocol, and then please adopt. Everyone should adopt same thing. So we have to find a way out. Individual cannot do it. I feel so always. So you just make a protocol with the think tankers and as per the ICMR guidelines, how to go about it.
Dr. Pooja, I would like to add here because it is a very important issue and asked to us in most of the webinars
Yeah. Yes.
about the withdrawing of life support and about the DNR guidelines. The base thing, again, I would like to highlight here that there are no clear-cut, though Dr. Hemant is saying that there are guidelines, but please remember these are guidelines. But there is no direct or clear-cut definition which all of our colleagues will understand what is passive euthanasia, what is active euthanasia, with all these things are there. But my suggestion is that any such situation where we are thinking of DNR or withdrawing life support, it should not be individual doctor's decision.
Yes.
Only Dr. Satish Tiwari cannot take the decision, though he is a medico-legal consultant. What I will suggest that if you are working in a hospital, then you take the medical superintendent in the confidence. If it is a medical college, we can involve dean also or the 2 or 3 specialists, like if it is a case of pediatric. But as we are saying, whether it is brain death is important or cardiac death is important, so we should have a neurologist or a pediatric neurologist. If it is adult patient, the neurologist and cardiologist or pediatric cardiologist. So we should make a team of 4 or 5 people who are expert in their different fields of brain, heart, and all this. And then the team should take the decision.
Right.
And
Yes.
if they are taking decision, then there is no problem, because if a individual takes decision, any of the relative can say that this particular doctor was in collusion with one of my another relatives and he has declared death, or he has withdrawn the life support so that the patient dies and we have the indirect benefit. So that,
Absolutely. Yes, the
to
point.
avoid that, the decision should be taken by a team of experts.
Yes, absolutely.
Okay, so we'll
moving
quickly
on to
go
our
on
NICU
to
cases. Archana ma'am would
yeah,
take
yeah, an ICU case. I think I'll not take one case. We'll just go on to and the next case. Now, 32-week-old female infant is born with some limb deformities. She is on CPAP for her mild respiratory distress. She's recovering, and slowly she started on feeds off oxygen, off CPAP. But we sense that the mother is showing no interest in the baby, not wanting to come and feed, etc. And you suspect that maybe she wants to abandon the baby. Any preemptive action at this point in time, Dr. Ramgopal?
Just a second. Can I just read? Because, okay, 32 weeks.
Yeah. Some limb deformities, female child, she's recovering, but she has limb deformities. Mother probably doesn't want the baby, is what you sense. Now, what should you do? Any preemptive action at this point?
See, the most important thing is our role is just to inform the police. If they want to go for adoption or whatever the help you can offer, but anytime, so it does happen that okay, deformed baby or sometime unwanted baby, their relatives refuse to take the baby. They just want to leave the baby in the hospital and run away. So most important is to inform the police, and in that case 90% the police take over the baby, and then they involve some NGO or anything and keep the baby in that NGO. But your duty is to inform the police and involve the police.
Okay, straight away you should inform the
Yeah,
police if you
100%,
suspect
yes.
something. Yeah. Is it possible that sometimes they may say, okay, हम लेके जाते हैं, but you have something in mind that can happen, but still you should inform if they are willing to take and you feel that the child's life is in danger.
Yes.
You should inform.
Yeah.
Our next case is a 30-week-old preterm baby with multiple problems. This question is for Dr. Gangulia. Multiple problems, develops NEC, is operated upon in a tertiary care hospital. The baby expires within 24 hours of surgery. Parents are not present and hence consent for post-mortem has not been obtained. Now, what is the action on part of the treating doctor? Many times these things happen. Parents just disappear when the things take a turn for the worse. And but there is we know that it is compulsory to do a PM if the baby or any child expires within 24 hours of surgery. Dr. Hemant, any comments on that?
So here the whatever you have narrated the question, the case scenario actually depends on the place you are working. If it is a hospital, if it is whatever the in charge of the hospital should be informed accordingly, first of all thing, and then whether to proceed with the PM or not, and then and the parents are not around, we cannot go ahead with that. We have to inform the police again, once again. So informing police, informing the head of the hospital in charge, and then deciding the case what to do. And basically, if the parents are not around, informing police will help in the tracing the parents and then according to proceed. Because PM is not an emergency, not an urgent one. So we can just wait and then decide accordingly. I mean, I think so in that time, we can have this everything clear about going ahead.
Okay. Thank you, sir.
Archana madam, very
Yes,
important.
sir. Yes, sir.
We are missing something very important in this case 3. Now, I have the basic question. Those who have prepared this case scenario, they have not made it a proper case scenario. Why do we want postmortem in this case?
So this is something that we have been told that if the baby expires within 24 hours of a surgery, that is an operative complication. You're supposed to do a PM. Is it something like that?
It is not an
Part of the
indication for
question.
postmortem. It is not an indication for postmortem.
Okay.
Postmortem has to be done only in 2 situations. One where the cause of death is not known. Here you are already saying that multiple problems, NEC is there and the child is operated also. So here the
This
cause
is a
of
real
death.
case scenario has been discussed, shared by one of our colleagues that this is what we believe, that if a child or a baby dies within 24 hours of surgery, we are told that you have to show that you have to do a PM because within 24 hours as an operative complication sort of.
No, madam. Please try to understand those who have asked the question and those who are attending. The postmortem is done only in 2 cases. One, if the cause of death is not known. And the second case, if it is a medico-legal case, like it is a roadside accident or some poisoning or hanging, like that.
Okay.
Where the cause of death is known, but still we want to do the postmortem in cases of hanging or poisoning to know the exact cause, whether it is the only cause or not. But if a case is known, the clinical diagnosis is clear, operative, as you have raised the question that within 24 hours of operation, then parents can take the objection that we want postmortem in this case because the operation was not performed properly.
Okay.
So parents can refer for the postmortem, but not the doctor will refer in such cases. Here we are very clear cause of death, so there is no need to do postmortem from our side.
So if the parents ask for such a thing, you may need to do a postmortem.
Yeah, so the question when the parents are not present does not come. Parents can only ask for postmortem. From our side, there is no need to do the postmortem.
Okay, sir. Okay.
See, where you see that the patient is going to blame you, or the patient feels that there is a negligence on doctor's part while operating, so that surgery has led to the death. Now, how do we prove that there was no complication during the surgery? So, if the relative starts blaming, then it is a potential case that it will go into the court of law. So, here the post-mortem is a must
Yes.
because we don't know tomorrow. There is no criteria for 24 hours, but when
Yes.
you see that there is a potential danger and tomorrow he may blame, so better to go for a postmortem. And
Yes.
once you feel there is a need for the postmortem, it doesn't require the consent from the parents. You have to inform the police. Police will decide what is to be done. Their rules and regulation for the postmortem, they will follow. Your most important point is to involve the police.
Okay.
And madam, if this is a real case and if you know the real answer, please let us know.
Actually, Dr. Geeta has raised her hand. She's the one who gave me this case. Let me
Yes.
see if she has anything here.
Yes, I think so. Yes, because sometimes practical things are different. Yes, Geeta madam, if she's around.
No, I don't think so.
No, she's
Anyway,
not there.
yeah. I think then we'll proceed.
Yeah.
Um,
But let inform us afterwards.
we will let you know, sir. The next section is
एक मिनट,
POCSO
गीता
and
मैडम just
Ma'am is here.
I'm there, she's there.
So next section is POCSO and I will ask
गीता मैडम को unmute करो, she wants to ask. She has written that please unmute.
Yes,
Geeta?
sir. Yes, sir. Just a minute. Ma'am, please try.
गीता मैम,
Yeah. So basically here the question was the death occurred within the 24 hours of surgery and the hospital has a protocol to take a consent from the parent that they don't want to do a postmortem.
Yes.
But the parents did not turn up. Once they came to know that the child is dead, they just did not turn up. So it was like we have been calling the parents, and the parents kept saying that they are coming, and they did not show up for almost 12 hours or even 15 hours post death. So, in this scenario, I mean, what as a pediatrician I would be doing?
So no, I will
involve the
we got
police. You have to
question,
inform the
madam. We
police.
got the question, madam. Hospital, if there is such hospital policy, inform police and hand over to the police. That is the only thing.
That's all. Let the police decide.
Yes.
You can issue a death certificate and hand over that death certificate to the police.
So basically, the whole thing is we did not ask for postmortem, but the hospital protocol was that they want a consent from the parent that they are not wanting to go ahead with the postmortem. Assuming that whatever arguments they can come up with.
Inform hospital authorities accordingly. Let them decide. Hospital authorities and police will decide.
Geeta madam, that is what we are saying, that from our side, doctor side, there is no need to take the consent. There is no need to say even that there is a need for postmortem. And what Dr. Ram Gopal has said is
So inform police, right?
Inform the
correct
police,
that
yeah.
if the patients are not turning up for taking the dead body, then you inform the police that such and such death has occurred and the relatives have not come to take the dead body.
Okay, thank you.
But there is no need for any postmortem recommendation from our side because we know the cause of death in this case.
So we don't want a postmortem. We just want the consent from the parent that they don't want a postmortem.
No, there is no
But
need to
as
take
a
consent.
consultant, you have decided that postmortem is not needed. Why are you asking the parents whether they want
No,
to?
it is a hospital protocol. It is not
So
my
that
You
protocol.
cannot make a
The
non-specific
patient is
protocols,
admitted
madam.
in a tertiary care hospital.
You cannot make a non-specific protocols.
I think,
Madam,
Geeta, you might after this webinar, tell the hospital authorities that they are doing something wrong and maybe they can change their policy.
their protocol is improper. Their protocol
Improper.
is
Yeah. Maybe Dr.
improper
Geeta can. Mhm.
because for
fine.
postmortem you do not need the consent of the parents. If the postmortem is must, you have to inform the police that we want postmortem in this case. And if the parents do not want, they should go and tell the police that we do not want postmortems. So police can take their consent. We don't have to take the consent. We have to only inform that we want postmortem in this case.
I think so. I think there is only one line answer what Geeta madam has said. If hospital policy is there, inform police and inform the hospital authorities. And
Yeah.
that's all.
Change the policy,
Thank-
because this policy
Yeah,
is not
policy is wrong.
foolproof policy is not there.
Okay. We'll move on to the next section, the POXO section, and I'll ask Pooja to please take over this section.
Yes. So in this case, a young girl was brought in by the mother with pain in abdomen, and she complains of pain specifically in the vaginal area. On examination, it revealed a ruptured hymen. Mother claims that she is 18 years old and is married, but you are not convinced and you suspect that the child is underage and is below 18 years of age. So what should be your next action? Hemant sir?
Domain of Dr. Satish Tiwari, sir.
Satish sir, your comments.
No, I think I had circulated one of my article that there are some legal vacuums and
Yes.
vacuums in the law and the legislation. If it has not been read by any of you, I will send it to Archana Madam again. But the things which are clear is that if the girl is less than 18 year, even if she is married, it comes under the sexual abuse and POXO. That is one thing should be clear. If we suspect that the girl has been abused sexually, even if she is married, you have to inform the police.
Yes.
And it is the duty of the police to investigate whether she is really above 18 or below 18. And as a doctor, our only role is that we can investigate as per our criteria like X-ray of the various bones and whatever may be the criteria for assessing the age. But if you have any doubt and if you have a what I will say Aadhaar card where it is clear cut that it is less than 18, then our duty is to inform the police. The inquiry and every investigation is the duty of the police to do.
Yes, just I want to add one line.
Yes,
We are
sir.
not the people who will be judging the age. So we are not going to decide the age. Whatever documents submitted by them, whatever it shows, and it is under 18, it comes under the POXO Act. We have to inform the police or the CWC.
Okay.
And
We-
let them investigate. It is
Yes.
the duty of the authorities to investigate.
Yes.
Okay. Fair enough. So moving on to our next case, sir. 5-year-old with injury in her private parts, allegedly due to a cycle seat while she was playing, was brought in by her female caretaker. If the history is clear that it was accidental while playing, is there any reason that we need to be cautious or should we suspect anything? Hemant sir or Satish sir, anyone who wants to take up this
See,
question?
any injury to the private parts, whether it is accidental, you have to inform the police. It's
Yes.
very clear. Under the POXO Act, any injury.
Dr. Ram Gopal, why any injury? If we have a suspicion that it is because
Also.
of the sexual abuse,
She is
then only.
specific about the accidental injury. So I said any injury, whether it is accidental or whether it
But
is a
she was
sexual
brought
abuse.
in by a female caretaker. In such scenario, also do we suspect?
Whatever it may
Whatever.
be. You are not the investigating agency. You have to inform the police.
Okay.
Yes.
Okay.
Pooja
Right,
madam,
also very
nobody
best.
can challenge your clinical acumen
Right. Got it.
other than the another expert in that field.
Yes.
Your clinical diagnosis can be challenged by another pediatrician only. Police or judge cannot challenge your clinical diagnosis.
Yes.
You are very much clear that it is not because of the sexual abuse. There is a obvious evidence that this injury can occur because of the cycle seat. You are very much sure that such type of injury will occur with that cycle seat, and you are clear that there is no sexual abuse, then there is no need to inform anybody.
Okay.
But if you have
okay.
any doubt that it can be not because of the cycle seat, but because of the some sexual activity or forceful sexual activity, then of course you have to inform.
I
So
see
just
Hemant sir
In
and
doubt,
Ram sir.
please
Sir,
inform.
but POXO Act says that even in
Yes.
accidental injury to the private, you need to inform the police.
No,
Let them
no.
decide. No, sir. Let them decide whether it is accidental or not. But it is our duty to inform.
So,
It's
Yes.
because
Gangulia sir, yes.
So then the bottom line is that if such a thing is there, you are suspicious or not, so that is okay. But it is there. So section 19 of the POCSO Act said you have to inform the police. That is
Exactly.
the
That is what I said,
and
sir.
let them investigate whatever is there. No.
Huh.
And we are not making the complaint. Most of our doctors get afraid that how the police, the relatives said, "Are your doctors ko mat report karo." It is we are informing, and whether their information that is nothing we are complaining. It is the information, and according to information, police proceeds. And if relative says no, it's nothing to be done. It is there to decide, relatives and the police to decide. We are nothing. We are just to inform and give the primary care, primary treatment we have to give.
Sir, I can give you the example which I don't want to
Yes.
name the doctor, but there are two gynecologists in Thane. One gynecologist, the case came that there is an accidental injury. She saw the patient, she thought that there is an accidental and she gave the treatment. Next day, the patient went to the another gynecologist where she reported to the police,
Yes.
and the first gynecologist there was in big trouble.
Yeah.
So it is always you inform the police. Somebody has, I think Dr. Amin has, does the act allow us not to report? No, you have to report.
You have to report. Compulsory section 19 states. No, about nothing. I'll do to the.
Dr. Amin, even if you inform the wrong thing, there will not be action.
Yes,
If
yes.
you know and you are not informed, then there will be action.
Yes.
Okay, so the message is that any injury to the private part has to be reported.
Yes.
Whether there was a female caretaker or anybody else, whether you suspect it's accidental or not, we have to report it.
No,
Don't trust
Pooja
anyone.
madam, again I would
Even the
highlight
female
here,
can cause a sexual abuse
if you are
nowadays.
very
It is
much
common.
sure,
Agreed, answer. Agreed.
Don't trust
if you are
anyone.
very much sure that the cause of that injury is it can be
Okay.
explained by medical disease, then there is no need. But
Okay.
if you have any suspicion, even 5% suspicion, then you must inform.
Okay.
Okay.
Now we'll quickly go to the mixed bag. I'm not going to take this question. We'll go to the next one. This is a 6-month-old baby brought with an unexplained seizure. You do a CT scan and it reveals a subdural hematoma. You also notice some bruises on her cheek. The parents appear quite attentive and concerned, and they seem to be apparently looking after the baby. But in view of the subdural hematoma, you admit the baby for observation. What are your actions that we need to take in this case scenario? Dr. Ram, would you like to comment on this?
See, when you expect there is a trauma to the child, so that is in the conditions which are suspicious. So you need to inform the police.
Yes.
Okay. Here again, you need to inform.
Any suspicious condition, you have to inform the police.
And
Simple answer.
And you have written bruises also and everything.
Exactly. That is what.
Maybe child abuse also.
Yeah, yeah. This is what this turned out to be a case of child abuse.
Yes.
And unfortunately, it's only a
Battered baby
6-month-old. We
syndrome.
informed the police,
Yes.
but the police also, obviously 6-month-old, the parents were willing to take back the child. So I don't know, in our country, I don't think there is anything like social service which takes away the baby. So the baby was given back to the parents. But anyway, you have to inform the police.
That
The
is not
message is that you
that is
have
not
to
our
inform.
job. We have to inform the
Our
police.
job is
That's
just to inform the police.
Yeah. Okay. Now this I'm not going to ask because we covered it in the ICU section. Now this is something which I really wanted to know, and I put this case here. A 15-day-old baby is brought by parents, and this is the last case, for a routine checkup. There are no birth papers available, and the mother provides a very sketchy history. You suspect something fishy, and you feel that you'd feel that maybe they have just taken this baby. What is the role of the doctor in this case? Second scenario is where the parents clearly say that the baby has been given to them by some relative. Again, here, what is our role when we know that they are not the biological parents and they have procured this baby other than Kara, some other method? What do you do? This question is for Dr. Hemant. Would you like to take the last question?
Actually, the first part is something fishy is there na. The whether the child is brought from his किधर से लेके आए तो it has to be informed to the police 100%. There's no doubt about that. informing police. And the second part is that I will leave to the Dr. Tiwari sir, because it has been given to relative. Now in our country, adoption is to be legalized and illegal adoption is not valid. So probably we have to inform, but I think so final answer will come from Dr. Satish Tiwari sir.
Yes, I totally agree with Dr. Hemant and Archana madam, as you already said about Kara. So there are definite guidelines for adoption in our country now. Nobody can adopt or just simply hand over our baby to the second any parents, even if they are relatives. But again, I will say this is the legal situation that you cannot adopt baby just at your level. But still in many families, देवरानी अपनी जेठानी को बच्चा दे देती है, बहन अपनी दूसरी बहन को दे देती है. So these things are happening. But as far as law is concerned, there is a definite law for the adoption, and whatever is done, it should be done with the, as a doctor, our role is just to inform the police and let them investigate whether the adoption was proper or not, whether they have taken with the consent or whether they have taken by some other means. So that is up to the police to decide.
So at the end, I would like to say, most of the times we are saying informing police, but please keep one register or one book which cases you have referred, when it was told, time, chronology of the event, because this inquiry may come after 6 months, may come after 2 months, because there is a limitation period of 2 years. So better always to keep some papers or register with us where we inform to police, and when we inform police, how the way you have informed police. There are two methods. Either you phone, call and ring 100, or you give the some. But what I feel always, you inform them on the phone, but at the same time on your letterhead, you just write the details what you want to inform. This is for information, please. This is to state that this, everything chronology signed by you, date, time, and please send this to the police station. Take their acknowledgement and they take their signatures and preserve one copy with you for further reference. So make a file that, and that file should be with the doctor in his cupboard, in his drawer. Will not rely on the subordinates or the workers who are working at the sisters. That is the most important message I want to say always. And at the same time, there is so many messages spreading across the WhatsApp regarding the period of retention of the records. There is nothing. There is only NMC said OPD indoor records for 3 years. Otherwise, there is no record. One of the questions in one of there is the CCTV record also there. The period of limitation of filing case is 2 years and 3 years in the consumer and in the criminal consumer. So at least ideally we have to preserve this record for 2 years or 3 years, whatever is there. And as per 3 years record preservation. But if you anticipate any complication, any mishaps, please preserve that papers for lifelong. And therefore we have to, but at the same time, when you destroy record, there is a procedure to destroy records. After 3 years, if you want to destroy record, please issue this advertisement in 2 local newspaper in two different languages that we want to destroy this property from this period to this period. Anyone interested to have their documents can please report. And after 15 days notice, one can destroy and just prepare the destroy report with us and keep with us on our official record. One more thing I want to say, in the rainy season or in everything, sometimes the flood comes, sometimes the record gets washed away and something the case comes. What I'm taking is the practical things which has happened and I get a phone call on this, and therefore I'm telling you, whenever this such thing happens, whenever you lose your case papers or sometimes it is stolen by something, and some patient also stole away the records sometimes. So whenever you find that your records are being stolen or destroyed by the natural disaster, please report to the police station accordingly and take the acknowledgement that this record from this period to this period has been lost or this period. So that will, because the litigation for that period comes, so you don't have any document to show that. So these are 2 or 3 important things which I wanted to say you. And basically, lot of gray areas in the medical legal issues. So I believe only 6 points, all 6 words only. Please try to anticipate, document properly, communicate properly. Please restrict to a limitation of your qualification to practice, and please follow the ethics, 4 rules of ethics. And at last, please introspect at the end of the day by keeping the patients in the shoes of your near and dear ones and how you treat it. That is, I think so, that is the point I want to say. Thank you very much.
Thank you so much, sir. And I'd like to thank the entire faculty here. It was really such an enriching experience. And I learned one thing. The friendly neighborhood policeman should always be your friend. You should go and make friends with the policeman so that because so many of these cases, you told us that you have to inform the police. So we need to keep them well in the loop. Thank you so much. And
Policeman should be reliable, otherwise you can.
Madam, believe me, at Nera where I practice at a Karjat Taluka, we have so much coordination with the police. I feel always police is helpful. And at present, the in charge of Nera police station is the BMS doctor. So we have very good coordination with him also.
Okay. So
We
thank
have a
you.
WhatsApp group of Nopada Police Choki with all the surrounding doctors.
Yes.
Yeah. So thank you, Dr. Hemant Gangolia, Dr. Satish Tiwari. So many new messages from you and Dr. Ram Gopal. I know there are gray areas, but on behalf of Thane Academy of Pediatrics and all the attendants, thank you so much for this wonderful webinar. We really learned so much. And I'd like to say a big thank you. Dr. Sudesha, madam, you want to make some concluding remarks?
And
You are
thanks to
muted,
Dr.
madam.
Archana,
Unmute.
thanks to Dr.
Sudesha madam,
Archana, Dr.
unmute.
Pooja, Dr. Sudesha.
Okay, thank you so much, sir.
Sudesha
Yeah.
madam, unmute.
Elena, can you hear me?
Yes, madam. You can just click
Such an
continue.
interactive session है ना. एक तो है कि पुलिस को अपना दोस्त बनाना ही पड़ेगा. And I think the first thing we'll have to go, I mean, जो नजदीक है, we are at Hiranandani. I think there also we'll have to have dosti with the police, which Archana is saying. So let's go together, Archana, and make friendship with the police. So that anything we have, just informing also. I mean, for that purpose also, actually, at least we should be friendly with them so that we can share whatever our problems are and they will respond accordingly.
Yeah.
Thank you very
Especially
much.
when
Thank
we are
you.
in trouble,
One
they should be able to
important point. Whenever you make an telephonic complaint, always write the name of the person and buckle number of the person. Always take their buckle number and name. Otherwise, you will say you have informed, but whom you have informed, you don't know.
Okay.
So the name could be same. So buckle number.
Okay. Yeah.
Madam Sudesha,
Sudesha,
if you are going to meet police station, if you are going to police officer, please that you see your branch must have received the email. In that there is a police office is there. Please make your office bearers to write your name and signatures and just meet casually. Courtesy meeting.
I think we'll do that. That will be most beneficial to us. And I mean, it will be any activity.
Safety precaution as well.
Yeah, that's a precaution we should be.
I will share the photos of what we do in Raigad. I will share the photos of the member submission to Raigad.
Yeah.
So nice.
Thank you everyone. Thank you, madam. Thank you, our esteemed faculty.
Archana, very well done. Huh?
Thank you,
all of you.
madam.
Congratulations to everyone.
Thank you, madam.
Very nice session.
Okay, bye. Thank you, sir. Good night.
Good night.
Thank you. Bye.